Sen.
We have a motion also. Ours overlaps considerably his, but we do have some issues that are in response to that I would address, and then I think that will probably avoid the need to separately argue my motion unless other issues come up.
Sir, when you're ready.
Thank you, Your Honor. Steve Sen, arguing for CareSync. I appreciate the court's read our memos, and Mr. Harris has also presented an argument covering a lot of ground. I'm going to try not to be redundant to either of those issues, but there are a few things for purposes of both emphasis, and because we do have a slightly differing approach to one of the arguments that we would like to go through. This is a public records case, and so the statutory definitions are a good place to start. They're in section 119.011, and there is included there the definition of public records as meaning all documents, papers, letters, etc., etc., etc. It goes on. Made or received pursuant to law or ordinance or in connection with the transaction of official business by any agency. It has been without controversy in this case that the Industrial Development Authority is an agency. They produced what they had to produce. The question is whether records that never got to the Industrial Development Agency but have been only with the accounting firm, CLA, whether those records can be subject. That requires looking at what the definition of an agency is, which takes us earlier in the same statute to subpart 2. Agency means any state, county, district, etc., just basically any unit of government, which all seems fairly clear, but then the complication comes at the very end of that definition, where it goes on to say, and any other public or private agency, person, partnership, corporation, or business entity acting on behalf of any public agency. Those words have been the source of much litigation, and most of the cases that have been cited in the memoranda are an attempt to make sense of what the legislature was intending. The balance of my argument is going to be from the seminal Florida Supreme Court decision that focuses directly on that. Mr. Harris referenced the case. It's the Schwab case, News and Sun Sentinel Company versus Schwab Twitty, and because I'm going to focus pretty closely on it, I'd like to distribute a copy to the court and to all counsel. The issue in the Schwab case involved an architectural firm that had been retained to provide architectural services in connection with school construction. And at some point the media wanted those records that the architectural firm had, made a request. The architectural firm said, we are not an agency and we are not providing the kind of work that would make us an agency even under that broadened portion of the definition of agency, and therefore we're not going to turn those records over. We're a private business in the business of providing architectural services. We're not an entity whose records are subject to the public records law. That issue went to the Florida Supreme Court, which recognized that the complicating factor was that final passage from the definition of agency involving business entities acting on behalf of any public agency. The question was raised, does that mean that anyone who enters a contract with any governmental entity therefore becomes subject to the public records law? And the court said no, it does not mean that. That is not what the legislature was concerned with. What was the legislature concerned with? The court answers that question at page 1031 under where the key number 2 on the headnote 2. This broad definition serves to ensure that a public agency cannot avoid disclosure under the Act by contractually delegating to a private entity that which otherwise would be an agency responsibility. The legislature knew that not all, everybody involved in government entities are going to be crazy about turning documents over, and there may be situations, and certainly the case law reflects this, where Different government agencies have made efforts to avoid disclosure of different matters, and because that these kinds of efforts to offload public records to private entities would allow folks who didn't want to have things public to give them just a wide door to go through, the legislature put that language in there to guard against it. And so immediately after recognizing that's the purpose of this language, the court says, we reject petitioner's contention that a private corporation acts on behalf of a public agency merely by entering into a contract to provide professional services to the agency. So where is the line? And it is something that, again, has been subject to a lot of litigation, and to a certain extent there's still some gray room there. But we do have the precedents that are out there that give us some solid demarcations of where the line should be. And we think all the demarcation the court needs for purposes of resolving this case is presented by this opinion that we're talking about. Now, the court did say it's going to be a multi-factor test. They looked at, a lot of district courts of appeals have looked at these multiple factors, the 9 factors. Mr. Harris, in his argument and in his memoranda, go through those 9 factors, and they do, if you undertake that analysis, point directly where Mr. Harris concludes they point. The Supreme Court did not go through all 9 of those factors in its determination. Rather, it focused on a subset of factors and found that that subset of factors, as they existed on the record in this case, were all that the court needed to look at to reach the conclusion that this architectural firm was not subject to the public records laws. And so what we have done in our arguments, rather than go through all the 9, is to focus exactly on what the court did in that case. And the reason we've done that is, we believe, our analysis is, that those exact same factors are present here in the same degree, with one exception, in which it is an even greater degree in providing a stronger argument that Clifton Larson Allen should not be subject to the public records laws. So we start with the analysis that the court undertakes, beginning at the bottom of page 1032, where they begin with the creation factor. The school board clearly played no part in the creation of the architectural firm. Well, it's certainly the case that the Hardy County Industrial Development Authority played no part in the creation of the national law firm Clifton Larson Allen, headquartered in Minnesota. That factor is just as applicable here as it was there, to the same extent. The second factor the Supreme Court looked at was funding, recognizing that while the architectural firm received public funds, they were given in consideration for professional services rendered, and were therefore no different than funds received by that firm from any other client. Clifton Larson Allen did this for fees, just as they do this kind of work for any other client. This same factor that the Supreme Court recognized in Schwab applies in this case to precisely the same degree and extent. The regulation factor, that the title that the court puts on each of these is in italics, kind of as an introduction to their consideration of the factor, and that's kind of a confusing terminology to use, but if you look at what they're talking about, they're talking about the independence factor that Mr. Harris spoke of in his argument. Is the contracting party going to be subject directly to the control and whims of the government entity, or is there going to be any independence and impartiality and ability to exercise their own discretion as they perform whatever the services are under the contract? And what the court noted there is interesting. They say the school board does not regulate or otherwise control the respondent's professional activity or judgment. In fact, under the terms of the contract, it appears the firm was to act as a neutral third party, interpreting the construction contract and acting as the judge of performance by both the school board and the contractor. That applies precisely to this case, and I would suggest it applies to an even greater extent in this case than it likely would have in that case. The entire point of this engagement is to bring to bear the independent judgment, impartiality, and lack of bias of Clifton Larson Allen with their credentials to examine certain questions as a impartial, unbiased decider. This was something that there was controversy about, and if you certainly as a government entity can grade your own papers and say I've investigated myself and I found I've done everything perfectly well, but that's not nearly as impressive as when there is controversy, bringing in a well-credentialed, impartial, unbiased entity to undertake confirmation of issues that were then in dispute. And the engagement, which is the contractual terms for the engagement, which are in the record, say that they're going to be conducted pursuant to the accounting attestation standards. That are published attestation standards that are attached to a memo that we filed earlier on and are cited in support of our motion for summary judgment, and those have been adopted by Mr. Harris in support of the arguments he has made. Those standards really underscore that you are not coming into an attestation in order to make your client happy and to do what they want you to do. You are coming in to be an impartial, unbiased determiner of the issues that are coming before you. So in the Schwab case, the court referenced that, yes, that's part of what architects do, provide independent interpretations in order to resolve disputes between the owners and the contractors and that sort of thing. But architects do a lot more. That's really the entirety of the engagement here. And so this factor, we think, is far more weighty in our case than it was even in the Supreme Court case. The next factor the court considered, decision-making process, noting that architectural services are not an integral part of the school board's decision-making process, or merely provided professional expertise. Clifton Larson Allen was making no decisions that are going to bind anybody. They were providing determinations that the IDA can then act on as they will. There was no delegation of decision-making power, as you have in some of these cases where a municipality will say, you go decide and take care of this so that we don't have to. They're getting this impartial report back so that they could then make whatever determinations they found proper based on that. So there is no delegation of decision-making authority, and so that factor also applies. A number of cases talk about the next factor the Supreme Court references, delegation of governmental functions. Some of the more extreme cases, I don't know if extreme is the right word, there is a view that some courts have expressed that there are actually two ways that a private entity can be deemed a public entity. One is through this multi-factor test. The other is if a public entity wholesale delegates governmental functions. Other courts say, well, they're not really two tests because governmental function is part of the Schwab factors, and so you're considering it in Schwab anyway. But it does appear, based on the courts, that this is one of the more significant factors, and if there is a wholesale delegation of what looks like core governmental functions, prison, things like that, that's going to make it more likely that they're public. There have been no governmental functions delegated here. There's no power to do anything. It's simply a request for a court to determine whether certain things are so or not. That applies here just as it does in the Supreme Court case. And finally, goals. Certainly the architectural firm may have been civic-minded. They may have been proud of the fact that they build schools. They may have gone to architectural school because they wanted to build schools that are conducive to learning. Similar to Clifton Larson Allen may be civic-minded and may be proud of the government work they do and the work they do for nonprofits. But in both cases, these are for-profit entities. They are doing this work so that they can get paid, so that they can put food on the table. The goals in the Supreme Court case said the firm's motivation for rendering professional services pursuant to the contract was clearly to receive compensation. That's why Clifton Larson Allen was doing this. It's not a pro bono project. And so that factor as well. You can go through the full list of 9 factors that the court noted as saying we see all the district courts of appeals have looked at these various factors, and we agree with that approach. We think it's an even more compelling case if you look at what the Supreme Court actually analyzed, the factors they actually considered, and recognize, as we think is clear on this record, that they are either precisely the same in this case or in at least one respect more powerful And our position is that the Schwab case compels the conclusion that Clifton Larson Allen was not an agency, even though it was a private entity that entered a contract with a government agency. With that decision, we believe the other questions that have been presented as far as protocol and things like that would become moot and would not need to be reached by the court, and so we will not.